When a severe accident happens at a workplace, the immediate environment is chaotic. But the Occupational Health and Safety Act imposes a rigid, immediate reporting framework that activates the second an injury occurs. We will walk through exactly what you need to do, identifying reportable incidents, securing the physical scene, and correctly executing the Ministry of Labor, Immigration, Training, and Skills Development reporting form. To execute this protocol, you will need the specific details of the incident, your employer business information, and a computer with Adobe Acrobat Reader installed. Following this administrative sequence replaces panic with process, turning a chaotic liability into a legally defensible and controlled response. This matrix outlines the exact parameters of a critical injury. Under the OHSA, this means an injury that places life in jeopardy, produces unconsciousness, results in substantial blood loss, major burns, or causes loss of sight. There are specific orthopedic rules. A single broken finger or toe is exempt from this category. However, multiple broken digits, or any fracture or amputation of an arm, leg, hand, or foot, which specifically includes the ankle, qualifies as critical. If an incident meets any of these criteria, or if there is a fatality, the law dictates that you must not disturb the scene. This diagram shows the only 3 legal exceptions to the non-disturbance rule. You may only alter the scene to save a life or relieve suffering, to maintain an essential public utility, or to prevent unnecessary damage to equipment or property. Preserving the scene exactly as it was ensures ministry inspectors have the evidence they need, which protects your company from obstruction charges during the investigation. This timeline tracks the mandatory notifications. At T0, immediately following a fatality or critical injury, you must call 911, call the ministry hotline, and notify your Joint Health and Safety Committee and the union. From there, the clock is ticking. You have exactly 48 hours to submit the formal written report to the ministry. Different incidents trigger different tracks. If a worker requires medical attention but the injury isn't critical, or if there is an occupational illness, you have 4 days to submit your notice. If a specific high-risk incident occurs at a project site or mine, even without injury, you have 2 days. Missing these deadlines stacks severe regulatory compliance violations on top of the initial workplace accident. Step 1 for the paperwork. Navigate to the Ontario Central Forms Repository and locate Form ON 00276E. This error screen is the PDF trap. If you attempt to open the file directly in Chrome, Edge, or Safari, the system will block you and tell you to install Adobe Reader 8 or higher. To fix this, right-click the download link, save the file directly to your desktop, and open it natively in Adobe Acrobat Reader. Opening the file natively activates the embedded digital submission tools, which are required to successfully file the document with the ministry. This is part 1 of the official form. For a fatality or critical injury, check the first box under OHSA Section 51. Scroll down to parts 2 and 3. Input your exact legal business name, your NAICS industry code, and the specific location of the incident, like the exact stairwell or loading dock where the accident occurred. In Part 4, specify if the injured person was a worker or a non-worker. Then enter the precise date and time of the occurrence. Next, draft the incident narrative. Write out the factual circumstances, describe the specific bodily injury, and provide the name and address of the doctor or medical facility treating the patient. Finally, document the contact information for any witnesses and fill out the Steps Taken to Prevent a Recurrence field. This field establishes the official permanent blueprint of how your company addressed the hazard and took accountability. To finalize the document, type your name to certify the information and click the PDF's embedded Submit button to route the data directly to the ministry. Next, manually email copies of this saved PDF to your Joint Health and Safety Committee, your health and safety representative, and the union if you have one. As this badge shows, your obligations don't end at submission. By law, employers and constructors must retain a physical or digital copy of this specific report for a minimum of 3 years. Securing these records provides the necessary legal documentation if questions arise long after the physical scene has been cleared. You have now secured the scene, executed the correct notifications, and successfully submitted a fully compliant OHSA report. Note one final caveat: if you are a constructor and the incident involved a structural failure or a crane collapse, you have exactly 14 days to submit an engineer's written opinion stating the cause. Strict adherence to this reporting protocol protects your workforce and ensures your business meets regulatory obligations. Direct links to the forms repository are in the description below.